All right, good afternoon, Facebook. This is Tony Martinez, and I am the broker of the Xtreme Realty group of companies. And I'm joined by our legal counsel here, Omar Arcia, Arcia, whatever area in the country you're from, you can pronounce it different ways, but you'll get a hold of him no matter what. And we're really excited. This is our first ever, so it's our inaugural Ask Our Lawyer show. The intent behind this show is to be a place that you can come to and get your legal questions answered as it pertains to Florida real estate. I would imagine that somebody from Ohio asking how they can do contracts in Ohio is a question you'd rather not take, right?
That's probably a question that I couldn't answer,
yeah.
And I would be losing my license if I start doing that.
Yeah, why do that?
No,
why do that over a simple question?
It's not worth it.
Not worth it, not worth it. So how about this, folks? Just to go ahead and keep the parameters straight. Let's have the questions deal with real estate. So here's a situation. You might be a real estate professional. You have a question on a contract that's falling apart. Can you do this? Can you not do that? Those are the kind of questions we want. You're a consumer. You have issues regarding renters, tenants, all these kind of things. All these questions we want to take. The intent behind this is that we want to add value as a real estate company and as a law firm because we feel that we operate differently from a lot of other real estate companies out there. One of my favorite jokes is that you can take a rock, throw it in any group, and it's going to land on somebody with a real estate license. So what makes Xtreme different? Well, we feel that we bring extreme marketing, extreme service, and we bring extreme results. Praise God, we've been able to grow significantly as a result of this strategy. We now have 4 locations. We have an office in Brickell, Orlando. We have one in Coral Springs, Lake Placid, and our main office here in Davie. So we want you to go ahead and send in your questions, and we'll try to get to as many of them as possible in this 1 hour we're here together. We are going to do this weekly, same time, same place. We want to start off with a topic that's near and dear to my heart, and that is I've always been an advocate to help people avoid foreclosure.
Right.
And you feel the same way.
Exactly.
And one of the things that we deal with so much misinformation out there on what you can and cannot do, and the confusion is between the real estate agents, the consumer, all the way across. But something that happened maybe 3 or 4 months ago that's a huge game changer that we've been out there preaching and telling that is going to bring a whole new wave of foreclosure cases. It's a recent ruling by the Florida Supreme Court as it pertains to the statute of limitations. So Omar, if you could share exactly what's this whole thing that happened and how does it impact and who should be concerned right now?
Of course, and listen, thank you so much for the invitation to be here. It really is a pleasure to be on Facebook Live. This is the first time for me,
okay.
but I'm very excited about it. I've been doing real estate litigation, both on both sides of the fence for the last 22 years. I've been involved not only in the litigation side, but also the transactional side. So I'm very familiar with real estate contracts. I'm also very familiar with the requirements and the underwriting that goes into effect when you do short sales. So we help clients from A to Z as it relates to any kind of real estate issues, real estate contracts, real estate litigation. That's really our forte, and that's really why Tony invited me to be part of the team. And I'm looking forward to being an integral part of this team and working with Xtreme to bring about great results for their clients and their brokers as they grow in a very significant way throughout the state of Florida and hopefully beyond. But turning back to the ruling that you were talking about, we were waiting for this ruling for several years because, as a lot of people are aware, banks basically were sitting on these foreclosures for years and years and years. And people thought that as long as the bank sat on the foreclosure for more than 5 years, well, you know what, they're home free. They're not going to have to pay a mortgage anymore. They're going to get a house free and clear. They're going to be able to move on or sell that house eventually to someone else and make all kinds of money. Well, that all changed. That all changed November 4th of last year when the Florida Supreme Court came down on the Bartram decision, U.S. Bank versus Bartram. Came down on November 4th, and what that case basically said is that banks now have the ability, because of the unique nature of mortgage contracts, to sue a borrower more than over the 5-year statute of limitations. So let's say that a borrower was sued for foreclosure a year and a half ago, 2 years ago, 5 years ago.
Okay.
And that case was dismissed. Now these people thought, well, the case is dismissed, it's over. The house is mine, free and clear. Well, the court said that with the moment that it got dismissed, the case, the relationship of the parties went back to the beginning of the relationship where there was no default.
Right.
But any subsequent defaults, now the bank can sue on.
Oh, okay.
As a matter of fact, I have a hearing in about an hour and a half on this very issue. Because of the fact that my client in that case was sued at one point, the case was dismissed, we got a dismissal of the case, and now he's being sued again. So now we're arguing that it's beyond the time frame allotted by the court, and actually they haven't done what's required under the Supreme Court. It's a sort of complicated decision, but the bottom line is that the banks can now sue beyond the 5-year statute of limitations under certain conditions.
So if I understand this correctly, the way it worked was, okay, the case was dismissed, and the bank had 5 years to sue again. And if they didn't, supposedly the statute of limitations had run out, they were free and clear.
Right.
Right. So then the Supreme Court comes back and said, wait a minute, the minute the case was dismissed, it reverted back to the contract as it was, and every month that they missed the payment became a whole new default date.
Right, you restart the clock every month. So the bank can actually choose any given month.
You just go, they can just go back to the last payment they missed.
Right. And then they would take 5 years from that date to the filing date. And as long as they're within that time frame of 5 years from that point forward, then they're okay. Now the one little nuance that the court kind of left up for grabs is, what does the subsequent default date usually mean? Does it mean the day after the last default? Does it mean a default date after the dismissal of the first action? Our position is a default date after the dismissal, because you can't be in default during a time frame when you're dismissing a case. Okay. So, and that's the argument that we're making actually in a hearing that we have in about an hour and a half on this very same issue. Exciting stuff. I mean, but the most important thing is people need to bring whatever concerns they have regarding statute of limitations. They need to meet with an attorney to get good, sound legal advice as it relates to your particular case.
Right.
You shouldn't guess
No.
at any of this stuff.
So if you are in this situation, maybe one of your customers or friends are in this situation, I think the first step is get the right legal help.
Exactly.
Okay, so because if it's humanly possible for anyone to help you be able to stay in the home, it's going to be Omar and his team. So how can they reach you, Omar? Throughout the program, let's give your phone number out, because people tune in for a little while and then leave. But what's the best way for them to get a hold of you?
Best way to reach me is going to be 954-437-9066. That's our office. Our office is located in Broward County. You can also go on our website, which is arcialawfirm.com, ARCIA lawfirm.com, and that has all the contact information, including email addresses and everything where you can reach out, set up an appointment online, meet with me personally to talk about your case. That's what's most important, is making sure that you're well represented, that you're giving good advice by people who have experience in the business. You don't want to go to an attorney that does criminal defense to get legal advice regarding how you can save your home from foreclosure.
Exactly.
And a lot of people do that.
Yeah.
And then they come to me when they're like a couple of days before the sale date and say, Omar, what can you do to turn this whole thing around in a couple of days? And I said, listen, I'm an attorney. I went to school to be an attorney. I didn't go to magic school. If you want a magician, you need to go to David Copperfield.
You know, it's one of my favorite sayings is, just because you can doesn't mean you should.
Right.
So what happens is, within the real estate world, you have a real estate license, you can do real estate all over Florida. Doesn't mean you should. And just because you're licensed doesn't mean you should do short sales or you should do commercial. The same thing. You know, someone that doesn't specialize in real estate or specialize in foreclosure defense should not be doing this.
Exactly.
And one of the things I like about you, one of the reasons why we hit it off, because normally there's kind of like a contentious relationship between foreclosure defense attorneys and real estate agents. I don't view foreclosure defense attorneys as the enemy, but I also know that not all foreclosure defense attorneys are created equally either, just like not all real estate agents are created equally. So my point is, and I train on short sales all the time, and I try to tell agents that want to engage in this area, don't go in with the attitude that you're there to help them do a short sale.
Right.
Because whether it's a short sale or foreclosure, the end result's the same. They have to leave the house. They're going to view you as the enemy. Why don't you go in there with the attitude of, have you looked at all of your options for being able to stay in your home?
Yeah.
And the reality is not everybody can stay in their home.
Exactly.
But I like the fact that if they go to you first and you've done everything in your power to keep them in the home or fight on their behalf, what happens? What should happen when you've exhausted all of your options? What should that person do then?
Well, I can tell you from firsthand experience, meeting hundreds of clients who are in foreclosure, what they'll usually do is they'll bring in a stack of documents, letters, advertisements they've received from other attorneys telling them that they can save their home. They'll bring in letters from other realtors saying that they want to sell their home. I can tell you firsthand knowledge that what these homeowners want to do, 99% of them, they want to try to save their home. They want to try to save their home. Now, out of those 99%, less than 50% probably will be able, realistically, to sell their home. But the one way I tell realtors, and the realtors that I work with, to stand out with those people that you do those that door knocking with, I mean, if you find folks that are in foreclosure, you go to their house, you knock on their doors, what you need to do is you need to be a helping hand for them.
Like an advocate.
Right. You want to be an advocate for them. You want to be a helping hand. You don't want to tell them, hey, why don't you call me so I can get rid of your house and I can earn my commission?
Yeah.
Because that's how it comes across. That's how the homeowner hears it.
Yeah,
right?
exactly.
The homeowner's hearing, hey, you want to get me out of my house because you want to earn a commission. And what the realtor needs to realize is that sometimes what you say doesn't necessarily translate the right way to the person that you're saying it. But if you're there to help them out, to give them a helping hand and help them through this process, they will never forget you. They will always come back to you as the person who helped me in my time of need.
Agreed.
So what I tell folks all the time that are realtors is when you visit them, advise them that they're in foreclosure, because a lot of people don't even know they're in foreclosure. Advise them they're in foreclosure and ask them, what do you intend to do with the house? And a lot of them will say, I intend to keep it. Well, have you hired an attorney? Have you hired anyone to help you through this process? And a lot of times these realtors will advise them that there's attorneys out there that can help them through this process. And then the realtors follow up. That's the difference. That's the game changer, is the realtors that actually will care. And they have a list of people that they visited, and they'll notate, person wants to keep their home. Follow up in 3 months. Follow up in 6 months.
Absolutely.
And say, hey, are you still working on keeping your home? Is there anything I can do to help you get to that point? Have you talked to an attorney? And obviously at that point, the realtor is free to recommend either my firm or 200 other firms that are out there that are doing the same thing that I do. But the important thing is that they come across to that homeowner
like they're trying to help.
Like they're trying to help.
And the reality is that when you've exhausted all of your options for helping them stay in the home, and they have no choice but to leave, we believe firmly that at that point they ought to look into doing a short sale.
Exactly.
Right. And that's where we can work together. We cannot be opposing forces. But you've done what you can. There's nothing else you can. You can't file any more motions. You can't get any more extensions. You tried to get a modification. It wasn't approved. Modifications. People have tremendous misunderstandings about modifications. And one of my jokes is, you want a modification, you want an MOD, you need a JOB.
Exactly.
Do they need a JOB to get an MOD?
You need a source of income to have a modification, because otherwise how are you going to pay the mortgage payments? A lot of people don't realize it. They say, well, the bank has to help me. The bank doesn't have to help me.
No.
The bank has to look at the numbers and see if it makes sense for them to stay in this deal.
Right.
If it doesn't make sense for them to stay in the deal, then they're going to deny your modification. And a lot of these homeowners try to do what I call operating on yourself. They try to go to court for themselves. They try to do the modification for themselves. They try to do the short sales themselves. They try to do all the follow-ups because the attorney they're working with, or whatever other home rescue scam they may be working with, doesn't know how to do that. So what ends up happening is a lot of these folks, by operating in yourselves, they kill themselves.
I know, they do. They think they're saving and they're not. So a different alternative. So one of the questions asked here is, well, what about deed in lieu? And there's a lot of misconceptions about deed in lieu and whether it's a viable option for someone or not. And I like to speak on it from the realtor perspective and everything else, and then from your perspective on the legal front. Do you see a lot of deed and liens happen out there? I don't think that a lot of them actually take place. What do you think?
I can tell you from my own practice, and we have a lot of active files. I see very, very, very few discussions about a
Right.
deed in lieu. Not so much actual deed in lieu getting done. Very few discussions
Right.
as to deed in lieu. The banks prefer a short sale over a deed in lieu.
Yep.
Because think about it. I mean, if you're with a deed in lieu, you're basically transferring the property back to the bank, and that may be great for them. But what if there's a second mortgage out there? What if there's municipal liens out there? What if there's permits that are open out there? What if there's all kinds of government fines out there? Stuff that may not be public record right away, that may require a more in-depth title search. Banks are very reluctant to take deeds in lieu because of that Pandora's box that can be out there.
Well, they don't want to own real estate. You know, they just want payments on the loan.
Right.
So what I always tell people, look, on the surface, a deed in lieu may appear to be maybe less stressful, because I understand a short sale is a stressful process. You have to open up your files, you have to let people come into the house, all these kind of things. But as you mentioned, the banks always want you to attempt a short sale first for at least 90 days. Okay? Then what a lot of times people don't realize is if the deed in lieu is not properly structured, if you don't get an attorney to review this document, you might still end up owing the money because they may not even forgive the difference there. Right. And the impact on your credit. Look at any mortgage application and ask you, have you ever had a foreclosure or a deed in lieu? It really is a friendly foreclosure.
Yeah.
It really hurts their ability to buy again in the future. And so there's other things that we can discuss. In fact, one of my agents was telling me that her customer called the bank because they're attempting a short sale, called the bank and they said, you know what, you ought to do a deed in lieu. And in fact, if you do a deed in lieu, you won't even have to pay any taxes on the money that's forgiven.
Right.
Hello? Let's talk about debt forgiveness, because people have no clue that in this wonderful country of ours, when somebody forgives debt, the government considers it to be what?
It's income.
It's income.
It's income. Yeah, and what I'm surprised about is that people still believe that forgiveness of debt means forgiveness completely of debt, and it's basically out of sight, out of mind. I don't have to worry about Uncle Sam. I'm good to go. I've moved on.
Right.
I can't tell you how many cases I have that I'm defending right now of people who were not properly represented either by attorneys or by realtors or by themselves, who did not get a waiver of deficiency and now are having to deal with a deficiency claim. And then even if we settle that deficiency claim, we're going to have to deal with some tax related issues. Had they resolved the deficiency claim back then, what was going on back then? You had the Mortgage Debt Relief Act.
Yeah, that's
which is gone.
It's gone. And it may never come back.
It may never come back. What that act did was, if you had mortgage debt relief up to $2 million on your primary residence, you were given absolute relief, complete relief of any taxes associated with that mortgage debt relief, because it was no longer really, it was the banks wouldn't pursue it. But that has changed. So now, whether it's your homestead property, whether it's an investment property, whatever it is, if the bank forgives debt, guess what's going to happen next year? By January 31st, you're going to get a 1099 for that debt forgiveness, because the bank got a tax credit for waiving that debt. Right? So now it's coming back at you. Someone's got to pay the piper.
And you know something, Omar, is critical, because in all of the times I've done short sale training, I cannot tell you how confused agents are about this. And ladies and gentlemen, if you're a real estate professional, you're at the front line. You're the one that has to be the best equipped to answer these questions and address these concerns. If not, people are going to make bad decisions.
Exactly.
Okay, so what is the reality? The reality is that if you do a short sale, a deed in lieu, if you lose your home to foreclosure, whatever the bank does not recover, whatever the bank doesn't recover is considered income to you. And when that law was in effect, if you were a primary homeowner and you fit the criteria, you basically had a wash. You were able to get out. That's gone. It ended, as you mentioned, the end of last year. And in the past, they've extended it and extended it and extended it, but there's no guarantee that they will do it this time around because it's
it hasn't been done, and it's unlikely that anything related to the 2008
Right.
home affordable modification program is going to continue
Right.
because of the makeup of Congress right now. So what's most likely going to happen is that the Mortgage Debt Relief Act is not going to be restated
Right.
or reenacted. We have issues with HAM. Obviously, home affordable modification programs are gone.
They're gone.
So right now, the only thing that you have available are modifications through Fannie Mae, or you also have modifications through the servicers themselves. They may have internal modifications.
Right.
But the home affordable modification program with the waterfall effect, where you had a HAMP 1, HAMP Tier 2, and you had all kinds of different permutations of that, that's gone.
Okay.
So it's become increasingly harder for us to get modifications now as opposed to before, and we're having to look at some very creative ways to help people stay in their home.
Okay.
A lot of folks don't realize that when they do have a foreclosure or when they're in the process of foreclosure, you have the absolute right to short sale your property.
Mm-hmm.
Now, you don't have the right to try to do a modification and at the same time do a short sale.
Yeah.
A lot of people
One
say,
kills the other.
right, can I do a modification? If that doesn't work, then I'll have a fallback because I'll do a short. No, you got to pick one or the other.
Yeah, one kills the other.
Right.
I just want to make sure that everyone understands, because on the issue of the tax issue, there are folks out there that will not attempt a short sale because they may have to pay or they will pay taxes on that money, and that's ludicrous. And that's where real estate agents come in, and we all have to step up and say, wait a minute, time out. If the law said if you did a foreclosure, you didn't have to pay taxes, but if you did a short sale, you would have to pay taxes, then it would be a short conversation. We wouldn't have any short sales. Folks, understand something. Whether it's a short sale or a foreclosure, whatever money the bank loses is considered income for you. That said, would you rather pay more or less in taxes? I think most people would say, I'd rather pay less.
Yeah.
How do you pay less? Well, have the bank lose less money. And traditionally, the numbers still support that in a short sale, the bank recovers more money than they do in a foreclosure.
Of course.
So the way you look at it, the bank recovers more, they lose less. If they lose less, they report less, you pay less.
Right, and especially now because the market is trending up to a certain extent. Property prices are strong right now. We're seeing that the banks are being more reluctant to take a lower price on a property. Back then, you remember back in the day, 2010, 2012, they were giving away properties. 30, 40%, 50% of fair market. Right? Because the market was in the tank. So right now, the market is strong. Whenever we process a short sale, we have cases where the bank is not only demanding that a potential buyer offer up the fair market value, but 10% above in order to do a short sale.
Yeah.
Because, and at the end of the day, like what you were saying, it benefits the bank a lot more to do it that way because of the fact that they're losing less, and it benefits the seller, the homeowner, because they're going to pay less in taxes.
Absolutely. Now, here's the thing. Make sure you talk to a good tax professional, because there is a loophole in there, and it's called the insolvency issue. If you can prove that during the time of that short sale, you were in an insolvent position. I always joke that insolvent is a fancy word for broke.
You broke.
Right. And then the degree of brokenness, that's a whole new word, right? The degree of brokenness can determine whether you have to pay any taxes at all.
Right.
So they look at your situation, and the example I've always said, if at the time you did the short sale, you had $600,000 in liabilities, and you had $300,000 in assets, and the $600,000 included the property.
Sure.
Right? Aren't you in the whole $300,000?
Exactly. No, but I mean, if you got to understand, again, this is all within the realm of a tax professional.
Yeah, we have to go speak to a tax professional.
We're going to give our disclaimer here. We're
Right
not
now.
giving tax advice.
Just say it again.
We're not giving tax advice because this is well beyond the realm of our understanding and knowledge.
Right.
But it's very important that if you are considering a short sale,
Talk to a tax
talk to your tax advisor, talk to your CPA, and ask them about an insolvency analysis in connection with the short sale, so that I can offset some or all of the benefit that you receive from the waiver of your deficiency. So you have to be very, very well aware of what your rights are, not only from the legal side, but also from an accounting side, to see if you can offset some of that tax liability.
Absolutely. You real estate professionals, you need to get a good tax professional on your team. If you're going to engage in short sales, and again, don't do it if you don't have the stomach for it, don't do it if you don't have the training for it, but you have to have a good foreclosure defense attorney on your side, you have to have a good tax professional on your side, and you also need a good closing agent on your side.
Exactly.
Great time to mention the sponsor of our show, our good friends from New World Title. Let's give it up for New World Title. They're going to handle the closing from start to finish, and they understand how short sales work. Now, just to change gears a little bit, one of the questions that was posed here is, would you please explain the benefits of involving an attorney in the buying procedure? Some buyers request attorneys to be involved in the transaction.
Well, if in any transaction, you want to have an attorney on your side, because there's so many things that can go awry during the course of any real estate transaction. And most attorneys, including my firm, charge a very nominal fee in connection with these contracts. I mean, if it's any agent of Xtreme, for example, they have access to our law firm with any question they may have regarding any transaction that they're involved in. And their client is not going to have to pay anything. Most clients out there are going to have to retain a separate attorney to defend them or represent them in connection with a real estate transaction. But as we know, there's always a nuance in a closing. I can't remember the last closing I was ever involved in that went through without a hitch. And if you ask the folks at New World, they'll also tell you, because they do a lot of closings, everything has a little wrinkle in it. And I get calls from them all the time to see if we can figure out how to get past that little wrinkle so we can get to close the deal. And that's my goal. My goal, as I told Tony and I've told all his agents, is let's look at ways that we can get past these little issues, these little obstacles that come in the way of getting the contract closed, so we can close a deal, so we can get your commission. So that's the benefit of having an attorney involved. An attorney will look at it from a practical perspective and from a legal perspective and come up with solutions, like we did in that case a couple of days ago, of how we can close the deal without having any stumbling blocks regarding any HOA issues, any lien issues, any issues regarding security deposits, extensions of the closing date, counteroffer issues. I mean, there's all kinds of issues in a contract that need to be dealt with by an attorney.
Would you agree that the typical real estate agent, the minute an attorney gets involved, they start freaking out?
No question.
You're there to screw up the deal, right?
And the way that
that's the mentality.
The way that most real estate agents look at it, not just real estate agents, but the public in general. Because, I mean, listen, we got a bad rap. You know, a lot of attorneys out there are looking to tear up deals so they can make money from it. You know, that's why we got that, that nice little talk that attorneys are like sharks. You know? You're swarming around looking for blood. Okay, my goal in every deal, and I've told your team members, and I'll tell everyone that's watching right now, my goal is to keep the deal alive so they can get to a closing. My goal is to keep the deal alive and get to close. And whatever I need to do to make that happen, I'm a practical thinker. I'm a solutions-based thinker. I'm not in it to tear up the deal. I don't make that much money litigating real estate cases. What I make, the money is establishing relationships with the people that I help close deals, whether it be the homeowner, whether it be the buyer, or the realtors involved. I can't tell you how many realtors come back to me and refer cases to me, really good cases, that are not even real estate related, because I was able to help them get that deal done.
So if you're representing, say, a buyer in a transaction, as part of the fee that you would charge them, you prepare the docs and everything? And
we prepare all the docs, and we also provide them legal advice along the way, and we provide them invaluable communication with the other side whenever anything should go wrong. It's very different when an email or a letter comes from our firm than from either one of the parties to the transaction or a broker speaking among themselves. You get instant credibility, and that's why I invited all your team members to reach out to us whenever you have one of these deals, so that we can bring credibility to the table on their side.
As far as the cost associated with it, the minute you get involved, of course, you're going to charge the customer a fee. But by the same token, then whatever fee the title company was going to charge for the preparation of the docs, that gets deducted, right?
Right.
So
most of the time, the fee that we charge is put in at the time of closing. So
Right.
it'll come out at the time of closing.
So they're not double billed. In other words, they're not paying twice for a situation like that.
No,
right?
I'm very, like I said, I'm very practical in the way that I handle these transactions. And my goal and my vision in every one of these transactions is get it to close.
Got it. Contract we have in our industry, which is the as-is contract. And there's a lot of questions and concerns and how it affects the real estate agent and the consumers as well. And earlier we were talking about the aspect that pertains to permits and everything else here. While I go check for some questions and everything here, could you expand on what things people should be looking for both as consumers, how it affects a consumer in a sale, in purchase, and the real estate community as well?
Yeah, one of the changes to the FAR bar contract is that they now require that when a title agent does their title search on the property, that they also disclose any outstanding municipal liens. That's a significant change from the previous contract, which didn't require any municipal liens. You got to understand, when they amend these contracts, especially when it's a FAR bar contract, you're taking into account legal issues that have arisen and have created litigation. And what the Florida bar in amending these contracts is doing is trying to avoid litigation. So they're requiring title agents to disclose any municipal liens that are out there. But the other critical factor that has changed, aside from the financing contingency, that's a whole show.
Yeah,
that
we should
can
talk
have.
about it.
But aside from that, one of the key issues is that if you have any open permits on the property,
which happens.
It happens all the time. You have a seller that starts doing work on the property.
Mm-hmm.
It's a pool, and then they run out of money, and they realize, you know what, I can't afford this house. I got to sell it. So you got a pool that's halfway done. You got a ton of open permits. So before, the contract only required that the seller produce or provide the buyer with anything in his possession, any permit issues or anything in his possession.
They must turn that over.
Yeah, they have to turn that over. But now the new contract expands that to far more than just what the seller has in his possession. Now the new contract requires that the seller provide whatever he has in his quote-unquote possession, custody, or control. What that means is not just what the seller has in his file cabinet in his house, but also whatever documents that seller's GC has, whatever documents that project engineer may have, whatever documents your architect may have, anything in your control, within your ambit of control, has to be produced over to the buyer. It's great because now the buyer has a better feel for what they're getting into.
Right.
And it's part of the due diligence process.
So by GC, general contractor, and so the contract, in some respects, that's good for the buyer, right? Now, there's aspects of the contract that one could say is not that great for the buyer, and that's the new financing part of it. So the way it's worded and the way it's meant is, as a real estate agent, as a buyer, you have to pay very close attention to the timeline for which you have to provide loan approval.
Right.
Because what happens if they go 1 day past the loan approval and they don't have it?
Well, if you go one day past that loan approval, you haven't provided notice to the seller that you have failed to get any kind of financing. You haven't provided notice to the seller that you've gotten financing.
You didn't cancel.
You can potentially, and you didn't cancel.
Right.
You can potentially waive your financing contingency, which means you got to go forward with that deal as a cash deal and close as a cash deal.
So the minute you didn't do any of those things, you didn't notify anybody, let's say you put down 30 days, and that's the standard, it's the default, 30 days. It's day 31, it's the buyer, you haven't said a single word. What's the seller to assume? The seller's to assume is that we're going forward like a cash deal, right?
Exactly.
Is that good? No.
Yeah.
No, that's huge.
Yeah, that is huge that's a huge change that could impact buyers of real estate. And the other huge change is, it went down from the approval period went down from 45 days to now the standard default is 30 days.
30 days.
Remember, they changed it back in 2015
With TRID.
when the TRID guidelines came out after CFPB said,
Right.
listen, this may take a little bit longer for folks to get a loan commitment.
Right.
And now there's no longer a loan commitment.
No.
So now we're going from 45 days back to 30 days. You don't even need a written loan commitment anymore.
No.
It could be a verbal approval from your lender. So, but what you do have to provide, people say, well, wait a second, it says that you don't have to provide notice here and you have to provide notice. Don't get confused.
Right.
You need to provide notice of whether or not you've got a loan approval or not.
Right.
Within that 30-day period, unless the buyer and the seller agree to an extended period.
Yeah, and see, so here's a scenario, okay? It's day 31. It's day 32. The buyer says, hey, I got it. I got the loan approval. And they go, and the seller can do what?
The seller at that point can terminate the contract because you're past the date. You didn't provide notice within the time frame. And keep in mind, guys, that every one of these contracts is a very important term in there called time is of the essence.
Yep.
Okay? Time is of the essence means something. There's a reason why it's in the contract, and it means deadlines are real. Deadlines mean that if you don't do something by a certain date, the other side can capitalize on it. And why would a seller want to cancel a deal? You know why? Because he may have a backup offer.
That's what I teach all the time. I tell my agents, look, you have to assume that the day that they signed the contract with your buyer, that same day somebody said, oh, but I would have paid you $10,000 more.
They can have 3 backup offers.
Yeah, and now they're looking at a way to get out of the deal. Folks, the seller has 3 days after the deadline to receive the loan approval. The seller has 3 days that they can exercise the right to cancel.
Right.
Even though the buyer comes up with the loan approval, the seller within those 3 days can say, thanks, but no thanks.
Right.
We're out
It
of here.
doesn't matter. He may have a great backup offer or a better offer. He may have, the deposit may be a meaningless deposit, so the seller can just walk away from it.
Yeah.
So they don't really care. So those are kind of issues that I think people don't realize happen every single day.
Every day.
In contracts, because sellers, sometimes they get seller's remorse, right?
Yeah.
And they realize, well, wait a second, how can I get out of this deal? I shouldn't have sold it for this because I got 3 other deals for $50,000 more on the table.
Right.
They want to terminate that contract right away. So it's important that you're very much on task and realize when those deadlines are. And just remember that under the as-is contract and the FAR contract, we're not talking about business days. We're talking about calendar days.
Calendar days.
Okay, so it's not 30 business days,
And
right?
and
Like the
weekends
CRIS
count.
contract, it's 30 30 calendar days.
And a lot of folks don't understand, because I get new agents all the time confused. Let's say you got 10 days to do something, 30 days to do something. The weekends count. The holidays count. It's just that the last day cannot be a weekend or a holiday.
Right.
And listen, the reality is, it's shameful, but there's a ton of real estate agents out there right now that don't understand contracts at all. And that's scary. And one of the things I pride myself on, look, you'll forget more than I'll ever know. But I feel as a broker, I'm the first line of training.
Sure.
I'm the first line of defense. I can't tell you how many brokers right now couldn't teach a contract class to their agents. They're constantly farming it out. Oh, go to the board. Go to the board. They'll teach you. Are you crazy? But I know what I don't know, and that's why we brought you in as our legal counsel.
Yeah, and then one of the things that I want to make sure that people are aware of is you're going to be notifying them of the fact that we're going to be having contracts classes.
Yep.
We're going to be doing classes on FIRPTA.
FIRPTA.
We're going to be making sure that these folks understand what the rights of their clients are in connection with these contracts on a much better level.
Absolutely.
One other reason why sellers would want to cancel that contract, it just kind of struck me, is that you may not want to wait to the closing date for the seller to say, you know what, we can't go forward with this transaction because you didn't notify me within the 30 days. What if that seller wants to remove that listing or take it off as active from the MLS and just relist it so that they don't waste any time getting the property out there? They may not want to wait to the closing date to return the listing to active on the MLS. They may want to just do it right away because they may want to get a better offer.
Another question asked is, we got this new form, but the old form hangs around for years and years and years. It almost takes like 2 to 3 years within the real estate community. So the old form, the old contract is still valid.
Yeah, I mean,
so
yeah, people got to understand that these are just forms,
right.
Okay, they're forms, and you can use the forms, or you can use your own contracts. Most respectfully, I tell people use the form, because especially the FAR bar contract form,
right.
because you've got the Florida Realtors and the Florida Bar Standing Committee on Real Estate that are creating these forms and are taking into account not only changes in the law, but also changes in case law, in cases that have led to litigation regarding these certain issues, and what they're trying to do is contract around it. So if you want to get to close the deal, you want to use the very latest form, and you want to use the FAR Bar 5 form. You don't want to use the 4X, you don't want to use the 4, you want to use the FAR Bar 5, which came out April 4th of this year.
Well, whenever we do any trainings, we always open it up to agents from all offices, because we want you to be trained. And look, I'm no fool. I think once you get a taste of what Xtreme is all about and our culture and the training that we provide, more often than not, an agent wants to find out more about joining our company. Something a pet peeve of mine, I don't know if you agree with this, on contracts. I cannot stand when a contract says that the closing date be on or before. My understanding, you're the legal genius here, is for a contract to be valid and enforceable, or for a contract to be enforceable, you need definitive dates.
Right.
If someone writes on, okay, that's definitive. Before can mean something very different to the buyer than to the seller.
Right. And in my contracts class, I always teach that you need to make sure that in the contracts that you prepare, not only do you have definitive dates, but you have definitive terms. You don't leave it up to up to chance,
right,
for certain things to come into play eventually. A lot of realtors, because perhaps their clients may not want to sign this, may not want to agree to this, will leave certain terms out. Regarding a security deposit, or regarding a subsequent deposit, or regarding how much they have to come up with to close, or regarding, like you said, on or before this date. And so listen,
right,
we'll work it out, as we go forward. You got to have a specific closing date. You got to have a specific effective date of that contract.
Yeah.
You got to know when there's an effective date of the contract. If there's a contract offer and there's a counter offer out there, you have 2 days to accept that counter offer.
Right.
Otherwise, contract is gone. So if they come in and they accept the counteroffer 4 days later, there is no contract.
Right.
So a lot of people need to understand those kind of issues that are very important to whether or not there's a valid contract. And if you have terms like on or before a certain date for the closing, that is not an enforceable closing date.
Yeah.
So it's basically you can close any time before that date.
Yeah.
And that's not specific enough.
No, yeah. The buyer may say, I'm ready to close right now. I can close tomorrow. And the seller says, wait a minute, I'm not done.
Yeah.
Now you got a mess.
Right.
And you know what? There are agents who have been in the business 20, 25, 30 years, and they'll use that. So it's not necessarily something that, how long you've been in the business is. That's just bad practice. It's bad contract writing. Another thing that confuses people is the inspection period on the as-is contract.
Right.
And they don't understand. For example, we had a case recently where our agent was representing the buyer. And the buyer elected during the inspection period to not go through with the deal. The listing agent was upset. I get it. We all want to close deals, but the listing agent says, no. My seller wants to see the inspection report. Is the seller entitled to the inspection report?
Not unless he pays for his own inspection report. So the inspection report is the property of the person who purchases it.
Yeah.
So you're not required to share it with anyone. No different than when you purchase a title insurance policy.
Right.
You purchased that title insurance policy. You don't necessarily have to share it with someone. You usually do, but you don't have to. And with respect to the due diligence period, I recommend that everyone do an inspection of the property, no matter how small.
By a professional inspector.
Right, by a professional licensed inspector, and obviously if they have any questions or concerns, I'm sure you can refer them to 20 different inspectors that are very qualified in whatever areas you have offices in that can do an inspection of that property very quickly. It's just good practice to have an inspection done, and it looks great on the broker too, because the broker in doing that inspection has provided sound advice to the client in terms of what they need to be doing. If you fail to provide that advice and you tell the client, don't worry about it, everything will get resolved. Don't worry about that moldy smell from the second floor. That's not mold. I don't see anything black on the walls.
Yeah.
Okay? So you need to provide the advice that's necessary for those clients to make sure that at the end of the transaction, they can turn back and say, listen, this broker really did a great job guiding me along this process and gave me sound advice for this process.
The inspection period reads that at the buyer's sole discretion, they can cancel.
Right.
Okay, so the inspection A should be done by a professional and licensed inspector, but doesn't have to be, right? Basically, they can just change their mind for whatever reason whatsoever during that inspection period and exercise their right under the inspection period to walk away from the deal and be entitled to their deposit back. Is that correct?
Yeah, and most people think that the cancellation within the inspection period has to be for cause. It doesn't. It can be for any reason. Like you say, you walk up to the second story as a buyer and you smell something that smells like mold.
Right.
Well, you can cancel right on the spot.
You get the heebie-jeebies. You feel something. I get the heebie-jeebies. I ain't buying this.
Right. You don't feel comfortable with the house.
I'm out of here.
You get that funky feeling in your stomach. That's usually something telling you this is not a good deal for you.
Right.
Right. So, but if you don't have to have an inspection, I mean, if it gets to the point where you get past the point where you have the troubled stomach about buying this property, and you're now serious about going forward with the deal, then get an inspector to go in there, qualified inspector, to give you a full analysis of what's going on with the property. Otherwise, you're basically kind of rolling the dice. But for any reason or for no reason, you can cancel within the inspection period.
Awesome. Okay. So one more time, how can they reach you, your law firm, for any of the things we've been talking about so far?
Absolutely. What our law firm is, like I said, it's located in Broward County in Miramar. The best way to reach us would be either by email or by phone. Our email address is info at arcialawfirm.com. info@arcialawfirm.com. Our phone, our direct line is 954-437-9066. We have an operator that will answer the phone. We'll set up an appointment with either myself or my other attorney, and we'll talk to your case. One of the things that I told you that I'm old school, right?
Yeah.
I don't do the FaceTime or Skype consultation. Okay. I don't do telephonic consultations. I don't give advice from the hip. I meet people face to face. That's what my old man always told me. If you want to do the things right, you meet people face to face. So I meet people face to face. Every single client that comes into my office will meet either with myself or with the other attorney in the office. They'll have an opportunity to basically lay out whatever questions they have regarding their particular case. We'll analyze the case. We'll give them sound legal advice. And you know what? There's many a times where I don't know what that advice is going to be. So I'm going to have to do some research on it. And I'll tell them, listen, that's a great question. I'm very rarely stumped, but sometimes I am.
Yeah.
What I usually tell clients is, let me do some research on it and get back to you. And I always get back to them. Always follow up with my clients. I'm always very accessible to my clients. And
what I like is, you actually give your cell phone number out to the real estate agents. When you teach a class, when you're in front of a group, you give them your cell phone number and you say, listen, don't abuse it, but the same token, I want to be accessible to you.
Right.
Because it's so critical. Again, I think if we can change the mindset, if real estate agents, more and more of us, can start viewing you, attorneys, as a resource and an asset, not as an adversary, it's just going to be good for everyone involved.
Right.
Yeah.
Well, what's happened is that they've probably had negative experiences with other attorneys that have kind of turned the transaction so that it favors the attorney as opposed to favoring the clients or the real estate agents. And our philosophy is totally different. Our philosophy has always been from day one is let's make the deal happen.
Yeah.
Whether it's helping people save their homes by defending a foreclosure, or if that doesn't work, one of the things, Tony, that I've always told you is any realtor that brings me a case where there's an active foreclosure and I'm defending that person in the active foreclosure, if it gets to the point where we can no longer represent that person, if a modification has failed, if we need to look at the option of short sale, well, that realtor is going to get back that case. I hold that sacrosanct. I want to make sure that people that are listening right now, that are hearing right now, understand that I hold that absolutely sacrosanct, and I will return the case back to that realtor so the realtor can complete the short sale or that process.
That's important because you work with all real estate agents. Obviously, you're our official counsel for Xtreme Realty team, but you have real estate companies and real estate agents from a multitude of different companies that use your services. And what I want them to understand is I want them to go ahead and send you those folks that need help with foreclosures, because when the time comes for them to need a short sale, you're going to send them right back to them. You're not going to turn it over to anybody else. You're going to turn it back to the agent that brought the person to begin with.
It's going to be a warm send back, and the reason why I say that is because I'm not just going to unload the case on the agent.
Right.
Okay. A lot of folks think, oh, well, they can't do the foreclosure. Well, he just basically throws the case back at me. Wrong. What I actually do is I will continue to work the short sale. Right. I will negotiate with the owner. We have an in-house loss mitigation team. A lot of agents don't realize that there's attorneys out there that have loss mitigation teams that negotiate short sales for them. And the agent no longer has to spend time on the phone, sending letters, organizing financials.
Absolutely.
So we take over that process. And it's included in the fee that the client is paying us to defend the case. And because basically what we do is during that process that we realize we can't get this guy a modification, we'll try to do other options. We'll try to do the short sale, and we'll continue negotiating for the short sale. And most of the time, what I've found is that when we can't get a modification done or a modification is denied, we've got all their financials. We've got all the information needed.
Yeah, you can segue into the other.
All I need to do is update their financials, update their W-2s, and send that off to the lender again under a short sale application.
Plus, you have the relationships. I mean, to me, I got to tell you, there's only a handful of agents out there that I can think of that are qualified to do their own short sale negotiations, and even them, they decided it's not worth their time. You know, as a real estate agent, you should be out there listing properties, getting buyers, keeping the sellers engaged, getting the best possible deal for the bank in that scenario so that they're more likely to do the short sale. Don't do the negotiations yourself. Leave that to the experts to go ahead and do that. Right. And just imagine the liability. I don't want any of my agents doing short sale negotiations. If they screw it up, what kind of liability is that going ahead and exposing us to?
You know, sometimes they say sharing is caring, but there's times when sharing is not caring.
Right.
And what ends up happening in some of these what I call flawed short sale negotiations is the person loses their property, has a foreclosure judgment against them, has all kinds of negative repercussions, and then now the bank is coming after them for the deficiency. And what's going to happen? These homeowners are going to look for a way to share their exposure or share the damages, and they're going to look to the professionals that help them along the way. And if the only professional they can turn to is a real estate agent, you can rest assured that real estate agent is going to get hit with a negligence claim or a malpractice claim.
Absolutely, absolutely. I mean, all it takes is for the agent to neglect to properly negotiate the waiver of a deficiency. Oh my goodness. And you know what? I want to close on something that a lot of folks don't realize. When HB 87 was passed, and that's the speedy foreclosure law back in 2013, which has sped the process up significantly within Florida as far as how long foreclosures take. It changed the time frame from 5 years to 1 year that a bank can pursue a deficiency judgment. But the wording says that those are in situations where it was a deed in lieu or a foreclosure. Short sale was left out.
Right.
I'll tell you, I've taught this a million times, and most of the agents had no clue that technically, if they do a short sale, the customer does a short sale, and there isn't a waiver of deficiency, the bank has still 5 years to go after them.
Absolutely, absolutely, and what we've seen happen is we're representing clients right now where they were improperly represented by an agent who had them sign a nominal interest-free note for the deficiency, and they thought, and let me tell you, that agent talked it up when that client came in and they said, well, you know, the agent who I trusted at the time told me this was no big deal, that the bank was never going to go after this. Lo and behold, the bank is now going after it because things have changed. Now they're coming back to me and they're saying, hey, can you help me? Well, you signed a note and that's binding.
It's binding.
Yeah, it may be interest-free, but you still owe the debt
Yeah.
personally. So it's either negotiate that debt with the bank or file for bankruptcy.
Yeah.
So, I mean, it happens. It happens. And to be honest with you, when you have a short sale situation and you have the Speedy Foreclosure Act involved, what ends up happening there is you need to be very conscious and conscientious of the dates where the bank filed the deficiency claim.
Mm-hmm.
They may be out of time.
Yeah, that's true.
So make sure that if you're facing a deficiency judgment claim, or if any of your clients are facing a deficiency judgment claim, that you send them our way so we can at least make sure that the timing on it is up to speed. Otherwise, the other issue that we have is, when they have one of these deficiency claims, don't present an appraisal of what the property was worth back in 2009. How accurate is that?
Yeah.
They'll do an appraisal today of what the property was worth back in 2009. Well, there's a certain level of subjectivity in any appraisal, right? Now imagine an appraisal that was done 8 years ago, or a market value 8 years ago. So you can challenge these deficiency claims based on a flawed appraisal. Or an unsubstantiated appraisal. We have a hearing on that tomorrow on the very same thing.
Okay. Well, we're starting to wind down, so what we want to do, folks, is to hope you saw value in this show, and we're just getting started. What's going to happen in future shows, and they're always going to be on Wednesdays at noon here, Eastern, 12 to 1, is we're going to bring different guests. We're going to bring in other industry experts to come in and share what's going on the number of different real estate related situations and issues. We want you to go ahead and visit our website, XtremeRealtyTeam.com. Send us your questions ahead of time so that we make sure that we can address all of your questions. If you need assistance with anything involving a real estate purchase, investment, selling, and renting, my agents are here to help you. We have 135 and counting licensed professionals throughout Southern and Central Florida. Reach us at our main number, 954-530-0211. That's 954-530-0211. So I've had a great time. Omar, I'm excited about this, brother. And it's just going to get better as we go along, right?
I agree. When we first started talking about this, I said, listen, we're going to be extreme. We're going to be extreme all the way. And I thought it was a great idea to do this, to come on live. And I mean, we're not technically giving legal advice, but we're guiding people.
Yeah, absolutely.
And there's so many people out there that just need a little bit of a push,
Sure.
a little bit of guidance, so they can go to the next step and get the information and the advice that they need. And I think you're doing a great job. Let's keep up doing that.
We will. Folks,
We're
thank you
gonna have to
so
get
much.
some more chairs.
Yeah, let's do that. All right, brother. All right, folks, thanks a lot. See you next week.